Welcome to Shaping Canada, 150 Years of Landmark Decisions. The Canada we know today wasn't built by chance. Argument by argument, judgment by judgment, it was forged by law within a unique justice system born from the union of the civil law and common law and increasingly Indigenous legal traditions. In this series, we mark the Supreme Court of Canada's 150th anniversary by decoding some rulings that defined our rights, our freedoms, and our collective identity. From criminal law to Indigenous rights and the division of powers, the decisions we chose to share with you are not just ancient history, they still shape our reality today. I am your host, Hugo Martin, and I ask you to join me for exclusive conversations with the 9 justices of the Supreme Court and leading constitutional experts as we uncover the context, the impact, and the lasting legacy of these judgments.
What does it truly mean to be equal before the law? Section 15, paragraph 1 of the Charter promises that every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination. To discuss the first major test of this powerful promise, we are joined by Professor Kerri Froc. Kerri Froc is an associate professor at the University of New Brunswick and a recognized expert on women's constitutional rights. Today, we are revisiting Andrews v. Law Society of British Columbia, a landmark decision from 1989 that shaped equality rights in Canada forever. Mark David Andrews was a British subject and a permanent resident of Canada who met all the qualifications to be a lawyer, except one. He wasn't a Canadian citizen. The Law Society blocked his admission. Andrews argued that this was discrimination. The Supreme Court had to define discrimination for the very first time under the Charter. Would they stick to a rigid definition or embrace a vision of substantive equality that looks at real-world impact? I am Laurence Lapierre, and I hope that you'll enjoy this episode.
My name is Kerri Froc. I'm an associate professor at the Faculty of Law at the University of New Brunswick. I'm also currently the H. Robert R. Scott Chair at the University of Saskatchewan College of Law.
Professor Kerri Froc, thank you so much for being with us and participating in Shaping Canada 150 Years of Landmark Decisions.
Thanks, Hugo. I'm happy to be here.
So today we're talking about equality rights, and let's maybe project ourselves to the late 70s, early 1980s. What was the lay of the land regarding equality rights and equality before the law?
I kind of picture myself as the camp counselor telling people to come around the campfire for horror stories, because back in the 70s and the very early 80s, it was kind of a horror story in terms of equality rights. So there's 2 really important elements of context. The first was the Americans and the interpretation of equal protection under the 14th Amendment. And there was a lot of problems there in terms of they had something that was called tiers of scrutiny, which meant that like the really, really bad discrimination was discrimination based on race. And then they had something called intermediate scrutiny, which was sex. And then there is like everything else, which was just kind of like, well, maybe as long as the government has a good reason for making distinctions or classifications, then they can do it. So based on the court's perception of what the really, really bad things are, you got kind of different levels of justice. So that was the one part. And the other part of that is the U.S. Supreme Court was insisting that discrimination had to be intentional. So if you didn't mean it, wouldn't necessarily get any constitutional scrutiny from the U.S. Supreme Court. So there was a lot of concern that Canada, if it got an entrenched Bill of Rights, would follow the same way. So that was like one part of the bad things that were going on. The second thing was the Canadian Bill of Rights, which was a federal statute, so it wasn't constitutional, but it also had an equal protection guarantee that seemed to be lifted from the American Bill of Rights. And there was a couple of really negative decisions that concerned women that caused people to wonder if it was worth the paper it was written on. So one was the Bliss case, Stella Bliss, and it involved unemployment insurance. And at the time, if you got let go and you were pregnant, you didn't necessarily have the same eligibility requirements as someone else that was let go. So Stella Bliss disclosed that she was pregnant to her employer, and the employer, as they often did at the time, just terminated her. So then she attempted to apply for unemployment insurance and found that she didn't qualify because she was pregnant. And the Supreme Court famously said that the Canadian Bill of Rights doesn't protect equal benefit of the law, it just provides equal protection. And it essentially just applies to penalties and not to benefits. And it also famously said that the law didn't discriminate against women, it discriminated against people that were pregnant. It sounds kind of silly to us, but it was following US jurisprudence that essentially found the same thing. Pregnancy discrimination is not sex discrimination. So there is another case as well that was called the Lavelle case that concerned what was called the marrying out provision under the Indian Act for Indigenous women. So if you're a status Indian woman and you married a non-status man, even if he was Indigenous, if he didn't have status, you lost your status. If you were a status Indian man, even if you married a white woman, she would gain status. So it seemed to be grossly, basically discrimination based on sex and possibly race as well. And the court said that because all Indigenous women, status Indian women, were treated equally badly, that there was no problem with the law from the perspective of equal protection, because the court said that it was equality before the law and not equality under the law, and you needed to have both of them. So those were kind of the baddies, and that was the state of play at the time that the draft charter became tabled before Parliament. So what women saw is, and there was a lot of back and forth about whether or not there should even be an equality guarantee in the entrenched Bill of Rights, because the provincial premiers were really concerned that this was going to give judges way too much power to fiddle around with policy, and they didn't want that.
But this was a common, I would say, complaint by the provinces when the Canadian Charter of Rights was drafted. Everybody thought for a while that the judges were going to have too much power. I'd like to go back to the Canadian Bill of Rights. So equality rights provisions can be found in Article 1B of the Canadian Bill of Rights. There's also the Canadian Human Rights Act, and there's a lot of similar provincial and territorial legislation regarding equality rights. However, these are laws, so a simple vote of the Parliament could have changed those laws contrarily to what the Charter gives us as a guarantee of perenity, I would say.
Right. And, even with respect to the Canadian Bill of Rights, there was some question as to whether or not the Canadian Bill of Rights would mean that judges could nullify other federal laws. So there was a question of, practically speaking, does it even do anything?
Tell me if I'm wrong the way I'm saying it, but the Charter of Rights is over and above all federal legislation. So you're telling us here that the Canadian Bill of Rights could be at the same level than any other laws, and could we use it to nullify something that we feel, a law that was felt as being discriminatory?
100%. And also, my home province of Saskatchewan was the first province in Canada to have human rights statutes. So we're very proud of that. But of course, with the division of powers, provincial human rights statutes only cover provincial laws and federal statutes cover federal laws. So in order to have uniform rights, basic rights across the country, you needed an entrenched constitutional Bill of Rights.
So we've mentioned the Bill of Rights numerous times. We're going to talk today about Section 15 on equality rights. Tell me, what was groundbreaking, let's say, about the adoption in 1982 of Section 15 called equality rights? And the first paragraph says, every individual is equal before and under the law and has the right to equal protection and equal benefit of the law without discrimination, and in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. This was groundbreaking, Professor Froc?
Yeah, I tell my students that it kind of sounds like a word salad, but there is a very good reasons for that. And as I just explained, judges were using very technical arguments to try to weasel out of actually giving people genuine equality. So the reason for that bit of a word salad is basically we mean equality no matter what. You can't try to say that it only applies to penalties and not benefits, or it only applies to the administration of the law, not the substance of the law. Essentially, Section 15 says no matter what the issue is in the law, there has to be equality. And even the title equality rights, that was fought over as well because it used to say non-discrimination rights. And women's groups in particular, but there are others, really insisted that there should be a positive element to equality. So rather than it being simply non-discrimination, it should be a guarantee of equality. And the third thing is you have an open-ended set of grounds. So there's a bunch of grounds that are listed. Disability in particular was a late addition because people thought, well, we make distinctions based on ability all the time. And there was some debate as to whether sexual orientation should be in there. And finally, John Chrétien, who is the Minister of Justice, just said, we're going to be here forever if we are endlessly debating what should be in and out. It's going to be up to the courts to decide whether or not any future grounds should be recognized. So this is the menu that you get, and judges can add to it. So it's an open-ended set, and judges can recognize new grounds.
The judges did have their say on this. And one of the landmark decision, one of the most important early decision on Section 15 is called Andrews v. Law Society of British Columbia. Professor Froc, can you tell us about the facts of that case?
Sure. So it was kind of a funny case to start our journey with Section 15 jurisprudence because Andrews was a British citizen that wanted to practice law in British Columbia. So not maybe the first person you'd think of when it comes to like terrible discrimination that is under the law, but nevertheless, that was the first case that went up. And the Law Society of BC had rules that you couldn't be called to the bar there unless you were a citizen. And ultimately, Andrews did become a citizen, did practice law for many, many years, maybe still practicing law for all I know. But it was a question of, number one, is citizen to be recognized as what's called an analogous ground? So a ground that should be read into the menu, as I called it. And second of all, was this discriminatory? Did this discriminate against him?
Just to make sure that everybody understands, being called to the bar just means that to be able to practice law, in this case was in British Columbia. Mr. Andrews was a British citizen, a permanent resident in Canada. How did we go about and say Section 15 applies also to these rules? It's not exactly a law that applies to a lot of people. It's not very much sweeping in scope. So how did the court decide that, yes, Canadian Charter of Rights and Freedoms should apply to Mr. Andrews? The trial judge, so the first judge that heard the case, dismissed Mr. Andrews' claim.
Right. And from what I can see, this was actually in the Barristers and Solicitors Act of the British Columbia statutes. So oftentimes it's a question of, well, who does the charter apply to? And it always applies to a statute because the charter says specifically that legislatures and the parliament and anything that they do is subject to the charter. It gets a little bit trickier when it gets to who is government, because governments are also included. So this was part of the statute, and that's why it was attacked by Mr. Andrews as being contrary.
I think I used the word sweeping in scope, meaning it's very specific to one person in one case. It just happened to be a Canadian resident, but not a citizen. And he wanted to become a lawyer. So that will not happen to a lot of people. Do you think it was a conscious choice by the Supreme Court to hear this case?
Well, it's always a conscious choice in that there's very few what they call appeals as of right, where you get to go to the show without the Supreme Court really having anything to say about it. Oftentimes, they have to grant leave to appeal. And it could be just simply a function of this case came up first as far as Section 15. And nevertheless, everyone was recognizing that it was an important case because it was the first one. So even groups that weren't concerned necessarily with the rights of non citizens, everyone was wondering and kind of on tenterhooks, wondering if the Supreme Court was going to screw it up again, to use the vernacular. And people were pleasantly surprised that, to a great extent, they rose to the challenge and delivered a good decision, a decision with some ambiguities, but a lot of the bad things people were fearing didn't happen with Andrews.
So let's talk about the actual decision. So, as I said earlier, it was dismissed at trial, but allowed on appeal, and the Supreme Court held the Court of Appeals decision. So let's dig deeper in this landmark decision.
So, as I mentioned, there are two elements. Is citizenship a ground that is covered by Section 15? And what exactly are we talking about when we say that something discriminates? What does it require? And the court goes on. Justice McIntyre, who was in the majority for this, says, there's three things we could do. Number one, we could say that anytime the law makes a distinction, that means it violates Section 15 and we go to Section 1. And he says that's not great because that really doesn't give Section 15 any substance. It basically trivializes it because all laws make a distinction, right? Or most of them do anyway. For instance, if you got the Income Tax Act, if you make more money, you have to pay more tax generally. And if you make less, you pay less tax. So that's a distinction. If you don't obey the speed limit, you get a speeding ticket. If you do, you don't. Those are all distinctions under the law. So it rejects that could possibly be part of the test. Another one came from the lower court, essentially saying that if the distinction is reasonable, then the government gets a pass. And that was Madam Justice McLaughlin, as she then was at the British Columbia Court of Appeal, that was advancing that idea. And the court said, well, that's not good either, because that doesn't give the Section 1 justification. When a government violates a provision of the charter, they can always justify it as demonstrably justified in a free and democratic society.
Which is Section 1 that you've been referring to earlier.
Correct. So that means that if we allow the government to make that argument within Section 15, that doesn't allow Section 1 to do any work. And by the way, the claimants have to prove that the law discriminates, but the government has to prove that any discrimination is justified. So that kind of upends the burden and puts too much burden on claimants. So the third thing is Mr. Justice McIntyre for the court said, well, what else can we do here? We have to have a distinction and something else. So what is that something else? And what he came up with is what is called the grounds-based approach. And it's essentially the approach that we still have today. So way back in 1989, which is the year of Andrews, he and the rest of the court established the test that essentially we still have today. So you need to have a distinction based on a ground. So that the grounds are kind of the gatekeeper for Section 15. So the grounds become really important. And the court said, because we can't just have distinctions, there's a something else. And the court really wasn't that precise on what that something else was. It talks about the fact that Section 15 is about making sure that everyone is entitled to the same kind of dignity and respect in society by virtue of the fact that you're a human being. So you're entitled to that kind of regard as a human being. But what I get from Andrews and what it seemed to be nudging everyone to, although it didn't come out and straight up and say it, is if you have a distinction based on a ground, you're almost home free because the grounds that are listed and the grounds that will subsequently recognize are some of the most invidious distinctions that law has made. The worst things, race-based distinctions, sex-based distinctions. So already those kinds of things are going to be things that are fundamental, that it's very unlikely that they will not be discriminatory. So as long as there's a distinction on the ground and it's kind of the sniff test that it's not kind of trivializing the guarantee, that's good enough. And the court really wasn't more precise than that, which led to a whole bunch of other problems and why we've been fighting about equality for the last 40 years now. But that's what it came to. And so that's what the test was. It also talked about the fact that equality is a comparative concept. So you have to be able to, put one side on the weigh scale compared to another group, but what that comparison wasn't super precise about that. It also said, again, that every difference in treatment doesn't mean that there's inequality, but similarly, same treatment doesn't necessarily mean equality. And in fact, the court said that some of the worst inequalities are going to be when people are treated exactly the same. We can think of the need to accommodate persons with disabilities, perhaps. So we have all of these kind of principles that it's remedial, it's comparative, that it doesn't mean everyone's treated the same, but it doesn't necessarily mean that differential treatment is discriminatory. So it's saying all of these principles, but what the heck does it mean?
The words without discrimination appeared twice in the first paragraph. So that's very important, especially for Justice McIntyre, like you said. And the grounds that are listed in Section 15 are race, national and ethnic origin, color, religion, sex, age, mental and physical disability. So this is something that we can all relate. So let's not discriminate on those grounds. They're listed.
And grounds that are akin to those grounds, but
Correct.
we don't really have an idea of what that means.
Analogous, exactly.
Yeah.
I just want to make sure that our listeners understand that what are the listed grounds, and then there's all the analogous or the related grounds that are maybe most linked to personal characteristics.
So I'm going to talk a little bit about another thing that the court rejected, and it's called the similarly situated test. That sounds like really complicated, but it comes back to Aristotle. It was a way basically to say, there's just some people that we know we can't give them equality because they're just so beneath us. And so Aristotle came up with this idea that equality really means treating people the same when they're similarly situated. And if they're not similarly situated, then you can treat them differently to the extent of their unlikeness. And That was the way, for instance, that Americans could say that every man is equal and still treat African Americans as lesser than. It was the way that, going back to Aristotle's time, you could treat women differently, you could still have slaves. And the court rejected that as saying that it begs the question, because what makes someone similarly situated might simply be prejudice that works into that kind of thing. And the court said that would even justify the Nuremberg laws of Nazi Germany. So that was a very strong statement that you can't kind of weasel out of equality by using this concept that there's just some people that are inherently unequal. So that's really important.
So not only they're saying the similarly situated should be similarly treated approach, they're saying that will not result in equality. And they're also saying that not every distinction or differentiation in treatment necessarily results in inequality. So there's the reverse as well.
The flip sides, yeah. So that's essentially a question that really wasn't resolved in Andrews is, well, you're saying that absolutely equal treatment doesn't necessarily mean equality, and you're saying that differential treatment might not discriminate either. So, like, what does it mean? And this was the ambiguity that really was a bit of a poison pill that put us in the wilderness for a while when it came to equality law. And it wasn't necessarily so much on when laws made distinctions that becomes important later on, but the question of what distinctions are discriminatory and which ones aren't.
Why was the Andrews case decided this way, that it was discriminatory?
Well, the reason why citizenship was accepted as an analogous ground is, and you had Madam Justice Wilson, who makes a really important interjection to talk about what she calls discrete and insular minorities, which is another legal term, but it essentially means that there are people that for millennia have been oppressed and treated badly because they're minorities. And she says that non-citizens absolutely fall into that group. There's wide swath of culture and laws that tend to treat them badly because they don't have representation in legislatures. They're not a group that can kind of marshal a whole lot of political power to make sure that they're treated with respect and with equality in the laws of our country. So she recognizes citizenship as an analogous ground, but this idea of the discrete and insular minority as what the heart of Section 15 is all about kind of jumps from analogous grounds to start taking shape as part of how to recognize when a distinction is discriminatory. So that was part of it. So that, the analogous ground. And again, because the court was almost saying that unless there's something that goes really wonky and recognizing a distinction based on a ground as discriminatory would trivialize the guarantee, we're going to recognize that it's discrimination. And the court said there's no reason to make sure that people who are lawyers, if you want them to, abide by the country's laws and make sure that they're patriotic sorts, there's other ways to do that. Like you have to say a little oath whenever you get called to a bar, become a lawyer of a particular province. There's other ways to do that. You don't need to make these kinds of distinctions in a law to do it. There's no reason for it. And the court called that an irrational distinction. And that kind of terminology comes back to haunt equality law. But it says essentially that's one of the markers of discrimination is when the law is making an irrational distinction. There just doesn't seem to be any real good reason for it to have that. It's something that seems to be like when people act irrationally against other people, prejudice often is behind that. And that's essentially what the court said here.
I'm sure that the Law Society of British Columbia did not intend to discriminate. What's happening with the intention of the law? Do the court need to evaluate what was the goal of drafting those conditions?
Well, there's two ways to think of intention, right? There's an intention to discriminate when you're making an explicit distinction. Like, we're still treating citizenship as the criteria, and we're treating non-citizens differently and worse than citizens, but we didn't mean anything bad or pejorative by that. So that's one way to think of intention. And the court essentially said it's not the focus on whether you're good people or not, it's the impact on the people that are affected by the law. So that's what the exclusive focus should be on. And then there's another part of intention where you can have laws that appear to be absolutely neutral. But the legislature was like, oops, we didn't even think of you because you're not really that important. So we didn't really think about what this neutral law would do in the real world. So that's another element of distinction, and the court said, "Well, that doesn't really count either because it's, again, the impact on the people that are being affected." So if there's what we call an adverse impact, then the court said that that can constitute a distinction even if you can't see it on the face of the law.
I'd like to talk about the dissent in this particular case, but mostly on the scope of Section 1, because we're basically saying in Andrews that the legislation was not justified under Section 1, and there's also other justices that says, well, you know what, it should be an exception. It is reasonable to expect that the newcomer who seeks to gain the privilege and status within the land and the right to exercise the great powers that admission to the practice of law will give you should accept citizenship and its obligation as well as its advantages and benefits. So there's two ways of seeing this.
There was a question as to whether or not, well, there's some distinctions that you can really see they really should not have the kind of scrutiny that other like baddies should. Like if you're saying like, no Black people should use this particular washroom, as was the case in the States, or you're saying that women shouldn't be lawyers, those are bad things because those do seem to be of a different ilk than saying that maybe you should be a citizen to be a lawyer. And so Mr. Justice McIntyre gets lauded because he's in the majority discussing what discrimination is and setting out the test, but he's actually in dissent on Section 1, and he essentially thinks that there should be more of a relaxed test for Section 15, and that's didn't carry the way for the rest of the courts. So Section 1 for all of the rights should be governed by the same kind of rigor, but you see the rigorousness of Section 1 kind of wavering, and you also see, which is a real problem in Section 15 jurisprudence, that you get this idea of reasonableness of the distinction creeping in from Section 1 to Section 15. And so people like me and other equality specialists are always kind of on the alert to make sure that the government's burden isn't being lessened by having those kind of considerations creep in.
So McIntyre and Lamer did say that the citizenship requirement is reasonable and sustainable under Section 1, given the importance of the legal profession in the government of the country. Professor Froc, it seems that the equality right landmark decision in Andrews seems to be a little bit trivial for what we mean by non-discrimination based on sex, race, religion, all these things. Now, what is the impact, according to you, of Andrews, and how was it used later in other cases or in shaping, basically, Canadian equality rights?
Thanks for that question. I can't overemphasize how significant this decision was. Some of the nightmare scenarios, especially that feminists and women thought might happen, like with the tiers of scrutiny and the similarly situated test and things like that, didn't come to pass. So everyone breathed a sigh of relief when we got Andrews because a lot of the things that were feared didn't happen. So that's the good part. And talking about, the fact that there's a large remedial component and sort of tipping the hat to a more positive interpretation of Section 15, all good stuff. But as I said, it didn't do everything, and some things it didn't do a great job of. It didn't do a great job of really explicitly saying that there's a positive element to equality. We had a couple of cases in 97 that emphasized that, but never to be heard from again. There's this tension between discrimination as involving kind of this irrational behavior on the part of government, or whether it really meant oppression and legislatures using their power to kind of squash groups that didn't have political power. So those were kind of the bad things. And this kind of circular definition of discrimination and what it really meant, it didn't do a good job with that. So almost immediately after Andrews, you get the court splitting into three factions, all of which had a different understanding of what discrimination was, which wasn't a good thing for Canadians generally to know what their rights meant, and even for claimants to figure out what's the case I have to meet. So that trilogy, as we call it, in the mid 90s, essentially meant that claimants had to make three cases rather than just one based on the kind of test that was used. And the court attempted to marry these different approaches in a case called the Nancy Law case in 99, but essentially just botched it worse.
So we're talking about a law v. Canada, I believe.
Yes, that's right. What the court said in law is, well, we know there's been a lot of ambiguity and a lot of chaos in the law, so it's kind of like the Lord of the Rings, one test to rule them all. So we're going to add a bit. We're going to say that not only does there have to be a distinction based on a ground, but this distinction has to violate human dignity. And it set out a number of contextual factors that the claimant had to address to show the distinction violated human dignity. But what happened with that is you almost forgot entirely exactly what was going on in the real circumstances of the claimant and whether there was discrimination. And the court and claimants became obsessed with this notion of human dignity, which was bad for a lot of reasons. But one of the main reasons is that it imported a lot of this idea of reasonableness into Section 15. So the very thing that Andrew said you should not do, essentially 10 years later was put back into circulation.
Can we circle to 15.2 maybe? Affirmative action or positive discrimination. Paragraph 2 of Section 15 says Section 1 does not preclude any law, program, or activity that has its object the amelioration of conditions of disadvantaged individuals or groups, including those that are at disadvantage because of race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. So we're talking, like I said, affirmative action. Also, basically specific provisions that permits laws, program, or activities designed to improve the conditions of disadvantaged groups or individuals. So do you think that law addressed a little bit that issue of 15.2?
Section 15.2, the affirmative action provision, was put in because, again, of trying to avoid some of the problems with the U.S. Bill of Rights. There was a case called Backey in the States where someone, a white applicant to med school, was disappointed that he didn't get in, and so he attacked the criteria that put some weight on a person's race for getting admission. We didn't want to do that in Canada. If you're trying to do something to ameliorate historic disadvantage, then the framers wanted to make it very clear that government is allowed to do that. So what happened is law didn't address that so much. But what started to happen, and CAP in 2008 in another case called Cunningham, the court really went to town on saying essentially, if the government really believes that what it's doing is trying to improve the situation of a disadvantaged group, then you get to bypass the Section 15 analysis completely. So it's this idea that if your intentions were good, then we'll give you a pass on this. And you can imagine the kind of problems that this created because, of course, government lawyers in almost every case were saying, well, laws are meant to have some sort of social benefit, right? So it started to pop up in almost every case where there was a Section 15 challenge, where there was a Section 15(2) defense that was attempted.
What you're telling us is that once those laws were contested, government lawyers started using 15(2) every single time by saying, no, 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 it's a affirmative action, it's positive discrimination.
Yeah, they were saying that this is something that benefits a disadvantaged group, and therefore you shouldn't even like do the Section 15 analysis. And it was kind of a do not pass go situation. And you talked a little bit about how law started that trajectory. It did in a way, in that one of the contextual factors that the court could consider is whether or not there was an ameliorative purpose to help a group that was more disadvantaged than the claimant. So it sort of put that poison pill in it, but it really didn't start rising to the surface until these later cases. And it wasn't till about 10 years later in cases concerning women's pay equity, a case called Centrale des Syndicats and Alliance, that the court said, no, no, no. Really, this is about a claim by a more advantaged group that this is reverse discrimination. So if you have a claim like that, then the government can bring in the Section 15(2) defense. But government, you can't use it in every single case. It's a very narrow band of cases where you could use it. And part of the problem is the court kind of puts these things in and then says, we've just had these things as kind of nuances or, philosophical enhancements. And really, we have never departed from Andrews, which is a bit disingenuous. If they had just come out and said, we're not following this train of doctrine anymore because we realized that it's caused more problems than it was worth, I think it would be a lot clearer for claimants. There we are.
Examples of analogous grounds, we have non-citizenship, marital status, sexual orientation. The court has held other instances that are not analogous ground. We're talking about place of province of residence, professional status or occupational status. A funny one was substance orientation.
Smoking pot.
Yes, yes, yes. So pot smoking is not a personal characteristic. Are you comfortable to talk about poverty? Because poverty has not yet been decided exactly whether it is an analogous ground or not.
Yeah, I'd like to talk about that. I wanted to also say that there's a couple of grounds that have been recognized in relation to indigeneity. First ground is Aboriginality residence. And then in the Dixon case, just recently, the court recognized non-resident status in a self-governing Indigenous community. And I think what the court is grappling with is that indigeneity is not race. Indigenous status is racialized. There's a cultural element and there's also a political element, as it's a nation within a nation. It's has a political element to it too. So that's why I think the court is grappling with indigeneity in that particular way.
There's Corbière as well, which is a Aboriginal residence, contrarily to non-resident status. And Dixon, like you said, the Vuntut Gwich'in First Nation, 2024. This is a very, very important case. Thank you for mentioning this.
But I did want to talk about poverty because that's a very important issue that you raise. And poverty hasn't been recognized or any other related grounds like receipt of social assistance because the court has said that immutability pursuant to Corbière is the focus. So immutability is things that you can't change, literally can't change, or that the government has no interest in asking you to change.
But that did not go to the Supreme Court. That was the Federal Court of Appeal in Alcorn, I believe.
Well, Corbière talks about things that the government has no interest in you changing. But in terms of poverty, there's been a number of lower court decisions that have said, no, poverty doesn't cut it because the court said it's not immutable and it's something that the government actually has an interest in wanting you to change. But the problem is that, one court called poverty a clinging web. I've actually looked at this issue of socioeconomic status, and every year some of my students in advanced constitutional law write about it because they can't believe it. If someone is poor as a child, I think the chances of them being able to escape poverty as an adult are in the low percentages, less than 10% kind of thing. And so it is not something that an individual can change easily. More people are asking the question is, immutability, is that really the end all and be all of analogous grounds? Is that really what the framers meant as being the linchpin? Because, the Pew Institute says that people on average will change their religion up to 3 times in a lifetime. So we have religion as one of the grounds there, but it's not immutable in any normal definition of that word, right? What else is going on here? And I think what is going on, and the court in Miron and Trudel did a really good job on this, is analogous grounds are really meant to be grounds involving groups that have historically been oppressed because of their lack of political power, because of dominant culture blaming people for their own oppression. And poor people definitely fall into that, and poverty intersects with a lot of the enumerated grounds. More women than men are poor. More Indigenous peoples than settler peoples are poor. More racialized peoples than non-racialized peoples are poor. So it has all of these kind of tentacles. Why not just, recognize it directly?
So, yes, they did say historically disadvantaged groups. Do you agree with me that analogous grounds is subject to evolve? I mean, there will be new analogous grounds at one point, not only the immutable characteristics of 15.1.
Well, that's what was meant to happen. Section 15 has an open-ended set of grounds because specifically they said the court will recognize more as the case law matures. But if you look at the list of grounds, there hasn't been a lot of movement. Yes, we have Dixon, but essentially that was nuance that was based on the previous ground of Aboriginality residence. They've become almost calcified in a way that I don't think is healthy for our constitutional democracy. And perhaps because of that, there should be another look at them. There's something going on here that is not what was meant by that open-ended list of grounds.
Let's remember that 15.1 does say in particular. So that doesn't mean that it's an exhaustive list, hence the analogous grounds.
Yeah, I'm kind of hearing a buzz more about the ground of family status, which hasn't directly been recognized by the Supreme Court. The court had the opportunity in Fraser to recognize that ground, and it didn't.
Professor Froc, how effective is Section 15 40 years later?
It's hard to say, in that I think the fact that we have Section 15, I don't think you can directly look at the wins and losses at the Supreme Court. I think that the equality ethos has permeated our way of life in Canada. Maybe present circumstances might begin to change that as we become influenced and more polarized because of what's happening to our neighbors to the south. So I don't think you can look at it in terms of wins or losses. And it's pretty pathetic sometimes when you do look. Women didn't win a sex equality case at the Supreme Court until 2018. The track record on cases concerning Indigenous peoples or race has been rather pathetic. The Sharma case, for example, was a very disappointing case concerning Indigenous incarceration and over incarceration. So I think it's, in terms of the doctrine, it's a bit of a mixed bag, but I can't really imagine, and I don't really want to imagine what our culture and society would be like if we didn't have it.
We have Section 15. Do we need Section 28? How do you feel that 15 and 28 intertwine?
Section 28, which guarantees equal rights to male and female persons. Andrews was so successful at kind of taking away some of that apprehension and fear about what equality rights could be. Section 28 kind of went into a bit of a hiatus because, as it's been explained to me by the women drafters of 28, it was meant to pull up the socks of Section 15 in case really bad things happened. At least we can save women's rights by the use of Section 28. So, to that extent, it wasn't necessary. I could go into kind of a longer explanation about some of the negative aspects of what happened to 28 in the interim years. But for present purposes, I'm going to talk about Section 28 as potentially the giant killer. We have governments that are more comfortable with using the notwithstanding clause. And it's fairly clear when you look at the legislative history of 28 and Section 33
Mhm.
that 28, its purpose in part is to make sure that whatever governments do with the notwithstanding clause, one thing they cannot do is invoke the notwithstanding clause so that there's a disproportionate impact on women's rights. So that's clear in the first clause of Section 28, which says, notwithstanding anything in this charter, and that includes the notwithstanding clause. Regardless of what you do, one thing you cannot do is have a disproportionate impact. So you can't have a law that discriminates based on sex and invoke the notwithstanding clause to preserve that discrimination, but you also can't have a disproportionate impact on other rights. So, for instance, with the Bill 21 and the law that allows people to be discriminated against at work where they wear religious symbols, what the evidence shows and what has been recognized by the Quebec Superior Court is that almost the entire impact has been felt by Muslim women who wear the hijab, and almost entirely has been felt by school teachers, Muslim women who are school teachers. So, what has been argued and what I argued in an early piece is that there's been a disproportionate impact on women's religious freedom that hasn't been felt by men that wear religious symbols. And you cannot have that under Section 28. So, to the extent that the invocation of the notwithstanding clause by Quebec has resulted in this disproportionate impact, the notwithstanding clause does not protect that, so the law could be struck down. You could either look at it as being struck down on the basis that it violates Section 28, or you could look at it as 28 blocks the notwithstanding clause so that there can be review based on these other rights.
Most comprehensive answer to my question of
I'm
cohabitation
sorry.
between 15 and 28. Thank you so much for this. This is very, very important. So, Professor Froc, recently you were counsel for the National Association of Women and the Law and David Asper Center for Constitutional Rights Counsel, alongside Suzanne Zacour and Cheryl Milne, in a case called Attorney General of Quebec v. Kaniinda. Can you tell us a little bit more about this?
Yes. So it's another Quebec case that concerns refugee claimants. So Kaniinda was a single mom that came over from an African country, and she claimed refugee status and was granted a work permit. But the problem was is that she couldn't access subsidized daycare to actually permit her to work. So, there was a challenge that she made under Section 15 of the charter, and that has And the Quebec Court of Appeal found that there was discrimination based on sex because of the disproportionate caregiving that women do. So, excluding a group of women, refugee claimants, from the subsidized daycare had a sex based effect. It was discriminatory. The question that went up to the Supreme Court is this discrimination based on sex? Is this discrimination based on immigration status, which to date has not been recognized as an analogous ground by the Supreme Court? And one of the things that National Association of the Women in the Law wanted to advance in the intervention is the notion of intersectionality, which essentially means that you can have discrimination that happens on an intersection of grounds. And this was something that was theorized by an American theorist called Kimberly Crenshaw. And she said that sometimes you can have this intersection, and race and sex was one that she used, where there can be discrimination based on either of those that Black women face. And sometimes they'll face racism, sometimes they'll face sexism, like white women or Black men. Sometimes it'll be discrimination on either of those grounds that are made worse by the other, but sometimes you can just have a completely different kind of discrimination that happens because you are a Black woman. So, this notion of intersectionality has been used by lower courts. For instance, there's a case concerning single mothers on social assistance that has been recognized by a couple courts.
Women and poverty.
Correct. So even if you don't recognize poverty as a ground, the intersection of grounds is something that is the bridge that the court has been willing to cross. So you have various governments that intervened in Canada, as well as the Quebec government, AG Quebec, saying, well, really, you're just trying to get in immigration status through the back door. And what National Association of Women in the Law and others have been saying is no, as long as you have an anchor based on an enumerated ground like sex, bringing other grounds into it for an intersectional analysis has not only been recognized in principle by the Supreme Court, but it's crucial if you're going to have a contextual kind of analysis of what's really happening. In order to give people genuine equality, you have to recognize not technical analysis like this is a distinction based on a ground that perpetuates disadvantage. You have to actually look at what's happening with real people, because Section 15 protects people. It doesn't protect birth.
It will impact Andrew's tests, basically.
To an extent, because you didn't have intersectionality that was at issue in Andrews. It was just citizenship. So it wasn't an issue there. They didn't have to address it, but Andrews left it open because that discrete and insular minority, right? You could have discrete and insular minorities that are impacted by more than one identity characteristic, for sure.
Professor Froc, thank you very much for enlightening us on equality rights. Our listeners will understand that this is a very broad question and it's constantly evolving. Our neighbors in the South are always also challenging our mentality on this. And I believe that the protection that we have through Section 15 is of utmost importance. Thank you again, Professor Froc.
And thank you. And we should all thank the framers and parliamentarians in 1981 and 82 for having the vision to give us such a good charter that has withstood the test of time.
Thank you for joining us for this episode of Shaping Canada, 150 Years of Landmark Decisions. As we've explored today, the law is not static, it is living. Every Supreme Court ruling adds another stone to the foundation of our society. For links to the decisions discussed and more information about our guests, visit shaping-canada.ca and make sure to read the show notes. Subscribe on your favorite podcatcher so you don't miss any part of this series marking the 150th anniversary of the Supreme Court of Canada. Thank you to everyone who contributed to this project. the Supreme Court of Canada, the Right Honourable Richard Wagner, Chief Justice of Canada, the Honourables Nicolas Cazirer, Suzanne Côté, Andromache Karakatsanis, Sheila Martin, Malcolm Rowe, Mahmoud Jamal, Michel Obonzawin and Mary Moreau, Professors Louise Langevin, Jocelyn Downey, Kerri Froc, Naomi Metallic, Karen Drake, Denis Nadeau, Félix Mathieu, Éric Labelle-Eastaff, Marcus Moore, Joel Bakin, Howie Kislowitz, Richard Moon, and François Tanguay-Renaud. Thank you to Maître Michel Lebrun, Miss Sandrine Raymond, Laurence Laperrière, and Laurence Thériault, Mr. Peter Warren, and our producer, Constance Saint-Pierre. This project has been made possible by the Government of Canada. I am Hugo Martin. Until next time.